appreciate your contribution. Permit me to introduce Rita Chindah. She's an intellectual property and information technology lawyer from Nigeria. She was recently listed in the 2020 WIPR Influential Women in IP Trailblazer. She has cognate experience in projects concerning data protection and privacy, media law, copyrights, trademark, and patent. Rita holds a master's degree in intellectual property and information technology from the University of Derby in the UK. She's an associate member of the Chartered Institute of Arbitrators UK Nigeria branch. Rita is also a co-contributor to the 6th edition of the International Cooperative Law Guide on Data Protection 2019. She has a podcast called IP Series on Anchor FM, which is also distributed on Spotify, Google Podcasts, Apple Podcasts, Radio Public, Pocket Cast, and Breaker, with a Twitter series also. She's an amazing person. Permit me to welcome Rita Chindah. Please, you have the floor to share your experience with us, and you will have 10 minutes to do that. Thank you, Rita.
Okay, thank you to the organizers. Thank you to the listeners. My co-discussants, you've done a very good job, and also the speakers have done a fantastic job in talking about trademark and due diligence that is expected of a lawyer. So yeah, from my experience, I think the main thing is that in Nigeria, most people only focus on IP registration, and that's an issue because we don't think big when it comes to IP registration. Can you guys hear me? Can you hear me?
Yes, we can. We can hear you. Go ahead.
Great. So first thing first, we need to think beyond just IP registration. That starts from the moment your client comes to your office, or they call you on the phone, or you're in a Zoom meeting. You have to, start thinking ahead. You have to start thinking like a business person. So based on the topic, we talked about due diligence. First thing first, you need to think beyond just IP registration. What are the things you can offer to your client after you registered their IPs for them? You also have to educate your IP on why it's really important for you to do an IP registration, and also create an IP strategy on how to expand or grow their businesses or their products or the services they wish to render. Then you come up with a strategy for your clients. Then you go ahead to do a thorough IP search, both locally and internationally, which has been emphasized on in this webinar. You also need to do a domain name search, just like how Mr. Max Okombi has talked about. And you start your IP registration, make sure that you have giving your IP attorney or agent the necessary information to facilitate your IP registration. Once that is done, and you've started growing as a business, you need to start looking out for trademark is more or less like a source identifier, while domain name is a website identifier. So those two go hand in. Take advantage or register your work before. And when it comes to trademark, first to register is what applies. However, in an event where you've been using your mark for a certain period of time without registering, you can always sue for passing off. Next, you have to, so when I talk about expanding, so if you're going to go into a merger, you have to do the needful, like getting your IP clearance, drawing up a checklist of the relevant regulatory compliance you need to do within the territory that you want to expand to. If the IP is for sale, do a thorough IP investigation to determine the real owners or the title of the IP, and also confirm if there's a pending litigation, which one of the speakers mentioned. Then you have to also do an IP valuation to determine the worth of your IP. So that's another important aspect that you have to talk about with your clients. So other than just registering, they also need to use their trademark. So for trademark, in an instance where you don't use your mark for a a certain period of time. And I think under the Trademark Act, it said the minimum is 5 years. If you don't do that, you stand the chance of losing your trademark. So there was one of my podcasts I talked about the Ferrari case with Aris. Ferrari registered its trademark in 3 classes: class 8, 20, 21, and 25, I think. And after the first model of the GTO 250 was created, just 36 model, they didn't use that particular mark again, and Aris was challenging it and asking that the mark be revoked. So you have to also advise a client that it's not just doing the IP registration, they have to consistently use it for commercial purposes. You have to use that mark for that duration, and as you use it, you keep expanding. So as we know, Amazon is like one of the biggest brand out there, and I think we have about 1,150 trademark. I always talk about it because it's mind-boggling how a brand can sit down and just think of how he or she could accumulate so much IPs in a particular IP. Then again, you also have to consider the option of doing a multi-layered IP protection. So one product or service or mark can have an industrial design protection, you can have a patent and you can opt to protect yours. So brands just focusing on Apple, a component that could also give them an edge, especially when they have to either go into a franchising or a licensing business at the end of the day. You also have to run things by your client. So you can't just on your own take decisions without consulting your clients or talking to them about what you feel. I did mention talking of creating an IP portfolio for your clients. So if you want to say you want to sell or you want to grow your franchise, that could be another asset for you. So you just have like a list of all the IPs that you have at the end of the day. Then be up to date with international best practice. I know that our IP laws are not up to date, but then you can, through your research and interaction with other practitioners globally, you can also give your clients the best advice there is out there. You don't have to rely so much on the Nigerian system. So this year in the trademark industry, globally, I think the case that most people were looking forward to was the Booking.com case against the United States Patent and Trademark Office, where it was finally decided that a generic mark affiliated with a top-level domain name is eligible for copyright for trademark protection, and that shook a lot of tables because most IP practitioners were against the idea that a generic term could be registered as a trademark. So I think that's another area that our jurisdiction needs to work on. We need to, look at things from the consumer's perspective, because what the Supreme Court and not the courts arrived at the end of the day, that is the consumer's perception that determines whether a trademark will enjoy protection or not, because it's not just an identifier, it's how you see it. Can I differentiate brand A from brand B if I see it at the end of the day? If I close my eyes at the end of the day and I go into a shop, will that be the first thing I pick? Then issues of likelihood of confusion again also comes into play. As a lawyer that has an IP client, you also have to be on the lookout for goods or brands that may be infringing on your client's trademark. So I think during the lockdown, a friend sent me a picture of two shampoo brands. One was the Head and Shoulder, and I can't remember the other brand, and it looked really similar. Now you can sue or inform your client that there's a similar mark out there and you want to challenge them for a trademark infringement. And that gives you gives you an edge that you actually know what you're doing. I know opposition state was mentioned by one of the speakers, and I think that's another area that most lawyers need to be very proactive about, because most times when I have people reach out to me and I tell them this is the due process for IP, and you can't, without the opposition state, you can't get that certificate, and you can't come and say you have a trademark at the end of the day, because if I am the one that gets it first before you, there's no way you're getting back that from me. So I did see a question where you was asked that if you did not register but you've been using your mark at the end of the day, can you still own the mark. So there are two different ways to answer that. You have the unregistered mark protection, and then you have an instance where the brand is a global brand and it has goodwill and reputation. Then that gives you an edge. You can also rely on that at the end of the day. I think Kanye West lost a trademark, or this year or last year, in China because of that. Even though the Yeezy footwear was coming out, it didn't have like a global reputation, so he lost that mark in China. And I think China is one of the countries that likes to take advantage of unregistered trademark, especially when you don't have reputation in those marks. Then you have issues of trademark in relation to right of publicity, but that's a bit dicey because other than the name, which is affiliated to the person, there's nothing else you can really bank on. And if the individual does make use of what he has, then I don't think at the end of the day you can come out to say, oh, you have an IP, or that's my IP, or anything like that. Then I talked about being up to date. Make sure you dot all the I's and cross all the T's. I know they already said out the benefits of trademark, but I said that a couple of rules that I think lawyers should focus on. I have a book, an IP law book that was hired by Mrs. It's very like my go-to book. This is what I use for all my research. So you have all the IP laws, but then you have the Trademark Act, and then you have the trademark regulation. I think under the trademark regulation, that's where you find most of these issues when it comes to opposition, correction, revocation, non-use, etc., etc. It gives you a more elaborate explanation as to what and how trademark operates. So if you really want to understand the trademark game, you need to know relevant sections such as Section 9 for distinctiveness and Section 19 on publication of notice of application, Section 20 for opposition of a registered mark. Opposition basically is 2 months. So you have to be, and I know recently I've seen a couple of tweets where the Trademark Registry made publications of journals that were being published, and then it's also included in the post that it's going to last for 2 months. So you also have to be on the lookout for that. Then you have Section 21, where you have to appeal from the registrar's decision on opposed application. Section 23 for duration and renewal of registration. I know one of the speakers talked about you being renewing your mark. A trademark originally lasts for 7 years, but subject to renewal for another 14 years. So that's another way for you to help your clients. Just like CAC registration, you have to assist your clients or let them know that their annual returns are due and the rest of it. Then you have Section 31, which talks about the removal for grounds of non-use. And then you have Section 40, where you need to do a correction with the registry. Then when it comes to IPGC, basically the Federal High Court has jurisdiction, but then the type of IPGC will determine. So like Max mentioned, when it comes to domain name, you can use the UDRP, which was created by WIPO. You can also go to the Federal High Court to file your suit, or you can opt for any other ADR procedure. I know last year, but this isn't copyright, this isn't trademark related, it's copyright related. Last year, Blackface and Two-Face settled their long dispute at the Lagos Multi-Law Court, and that was like a step in the right direction. I think this year a lot of the artists are leaning towards resolving dispute out of courts instead of I think a lot of people have been doing a lot of social media color. We saw the First Bank case. Which other case again? The living in bondage case. But then, as lawyers, I think you need to be proactive. You need to think like a business person, especially as a trademark person, because trademark is like one of the most exploited IPs where trademark owners can utilize it in any way they want. So yeah, I think that basically covers it. I don't know if my time is up. Is my time up?
No, you can just conclude.
Okay, so in conclusion, think beyond just IP registration. You have to find out ways to help grow your client's IP. You can advise them, help them draw up an IP portfolio. So you give yourself a timeline where you can do IP valuation and determine whether your client can get loans for projects. So we've seen a lot of issues where people go to pitch ideas and then it's stolen. But in order for you to do that, you need investors. So if you want to get investors, you need to build your brand, and that process that gets you to the point where if your IP is evaluated and you can it can be a huge sum and you don't need an investor at the end of the day. You can just focus on that. You can also opt for trademark research and development R&D at the end of the day, and then make sure that whatever you're doing is in line with what Nigeria basically regulates when it comes to trademark, and also look out for the other industries that has an interface with IP or trademark related. So I think I'll end my presentation here. So thank you guys for listening. I'm done.
Thank you so very much, Rita, for that beautiful presentation. We are indeed very, very grateful. Now,